Somewhere away.
Can't hear you back here.
I'll sound off. How's that? There we are. I'm Todd Lochner, and I'm a local admiralty attorney. I do a little bit of blue water. I've done some work for the Dome Chartering and the Skylar Lines guys, but my branding has primarily been in the recreational market. I'm here to talk about a whole variety of topics if we need to, but what I've been asked specifically to discuss is the clarification of the surveyor duties. What are they and to whom do you owe them? Because that can be a sticky wicket right there. So we're going to do the following. We're going to talk about the sources of duties. So here's your roadmap. Then we're going to move on to the few other duties that you really need to know about that are not yours, but you can't do your job unless you know them. Third, we're going to share some of the sources of guidance. So when you walk out of here and you're left with, what do I do? You're not going to remember anything that I say over the last hour, but you hopefully will be able to go back to the sources of guidance and work through your own sticky wicket of ethical problems on who do I owe a duty to or not. Then we'll do a brief overview of the causes of action that are out there. This is the CYA. Everybody knows that acronym, right? So this is you have to know what they are before you can do the CYA. So we'll give you a brief overview of what's out there for the surveyor liability. If and only if we happen to have an abundance of time, which I do not anticipate, we'll take a look at some of the few cases that are the seminal cases out there in the United States. You'll find when you get your handout in a moment that there are a lot to do with classification societies. Part of the reason is, frankly, the class litigation ends up going all the way up, but the classification society cases apply to what you're doing. So with no further ado, I'm going to begin by figuring out who I have in the room so I can start to tailor what we're going to talk about for the next hour. How many of you are doing cargo work? Anybody crazy enough to do HBI? The hot brick ingots? No? Okay. So what kind of cargo work are you doing? Just a couple of people who said yes. Various bulk, different stuff.
Petroleum projects.
I'm sorry?
Petroleum projects.
Petroleum, okay. Anybody else, something in the vastly... Okay. That gives me an idea on the cargo side. How many folks, because not everybody raised their hand, how many folks are really focusing on the haul work, whether large or small? Okay.
Define small.
Well, let's start with this to delineate the room a little bit. How many people are just doing blue water ship work? Okay. How many people are also doing the brown water supply vessels and things like that? Okay. And now how many people are doing the yachts, the recreational? All right, I have a huge variety. I would say if I had a majority, there's a lot of people doing the yacht stuff, which is easy for me because that's, clearly why I've been doing a lot of branding on that for the last 2 decades. And most of my cases defending surveyors have ended up being in the yacht side. Somebody once wrote, never take a lawyer as your client if you're a surveyor because you've increased your chances of being sued tremendously. So I've seen that happen when I'm defending surveyors. And now the other big piece of this, to make sure I know who to talk to and about what, how many people are doing casualty work? Anybody doing casualty, whether it's small vessels, large vessels, recreational, working for the insurance companies? Say again? Damage claims, yeah. The casualty work, the damage claims. Okay, a little bit? All right. It gives me an idea where to go with this thing. Let's start with the big picture. To whom do you owe duties? There's one really popular answer, and I'm going to ask just a couple of random people. To who do you owe the duty?
The guy paying the bill.
Bingo. The hand that feeds me is the answer, and yet may or may not be correct, depending upon a whole host of factors including what's in your deal, what's in your written contract, including the purposes, you may or may not only be beholden to the hand that's feeding you. In fact, there are certain circumstances where you don't actually owe any duty to the hand that feeds you. But that's the popular answer, the one I was expecting to get, because that is the reality answer. Okay, so we have this weird thing here, and I'm a weird lawyer because I don't sugarcoat it. I'm pretty well known for being overly blunt. The overly blunt part is we have this objectivity. It's in the ethical codes. We're all trying to be objective. We're trying not to become known as the whore surveyor that anybody can buy. But you have the competing interest that you are, in fact, being paid by someone. I'm just putting it bluntly. And you don't want to get that label. And there are some folks out there, I will tell you that some of the lawyers, you see somebody pop on a file, they're a whore. And the response from the lawyer who hired them, yeah, but they're my damn whore. It really happens. These are actual conversations that happen all the time. So you have to be objective because you don't want to get that label, because your reputation is really what you have. So this is why it's super important to know exactly where your duty lies. And the hard part is that whoever's paying the bill, it's human nature. There's a natural inclination to go, that's who my duty is for. But it may not be so. A couple other things that I've heard. The yacht brokers, I've heard this one before too. My duty is to the deal. What? Your duty's to the deal? Well, of course, they're getting paid only when the deal closes, right? It's a sort of a variation. And it's the variation of the hand that feeds me. Because you can't have a duty to this thing called the deal. You have a duty to a seller, you have a duty to a buyer. But it permeates our entire society. And then the other one that I love hearing sometimes is I have a duty to the truth. I've heard that from surveyors. I have a duty to the truth and only the truth, and it is what it is, etc. That is overly simplifying the reality that you have a duty to someone, to some entity or individual. In order to figure out who the duty is to, we also have to understand the sources of the duty. Just for the follow along part now, I don't want everybody to have their head buried in this, but as we get into the, actually we'll do, why don't we take halfsy and pass them back. So I don't want you to get your head buried into the paper, which is always a fear when I hand out a document before we finish talking about it. But this legal stuff can get thick. It can get thick. So this will be a sort of a guidepost. We're not doing line by line. You'll see that in the first page, half of what I've been talking about for the last 10 minutes isn't even on there. But there is stuff as we get further that you can refer back to when you don't remember a thing that I've said. So take it with you and we'll do the guideposts. The first place where we need to look at where does a duty arise is a fiduciary duty. Now before everybody gets a hold of it and has the definition in front of them, who wants to venture a guess at defining a fiduciary duty? Anybody? Go ahead. I'm sorry.
In the contract?
Contract can define a duty by all means. A fiduciary duty is when you have an individual duty, and I've given it to you on your document. Specifically, I took out all the legalese garbage that doesn't matter, and I've given you the 5 lines that do matter in the definition. Right there it says, quote, a relationship in which one person is under a duty to act for the benefit of another on matters within the scope. There are 4 different things, but only one you guys care about. When one person has a duty to act for or give advice to another on matters falling within the scope of the relationship. So your answer about contract is perfect because in a contract, you define the scope of the relationship. But quite apart from that, you may have a fiduciary duty to someone or some entity. Now, this is where it starts to get a little complicated because you guys are doing international work. Is that correct? Or are you mostly US or? So we've got some international, you know, lawyer's chorus. Laws may vary from jurisdiction to jurisdiction, right? You've heard something like that on the TV. This is, of course, since we're sitting in the US, going to be primary US based because a lot of people here are that. But the problem with that is we've got how many states and how many different jurisdictions? I can tell you this fiduciary duty concept is a state law concept, and it can be different from one place to the other. Right now, the state you're sitting in, at the state's highest court, they have a case where they have previously rejected a separate cause of action for a fiduciary duty breach. Like, well, why are you talking to us? Because a lot of other states have it. You just happen to be sitting in one that doesn't have a direct action for a fiduciary duty breach. Like, nobody could sue you. This might change by next 2 months from now. Nobody could sue you on just fiduciary duty, period, and say, that's my cause of action. But in other states, they can. But wait a minute. I thought maritime was this uniform body of law, right? Well, that is a nice fiction that we try really hard to press courts on. But the reality is there are a lot of state law topics, particularly in what you guys are doing. Because some of what you're doing is by its very definition, if you're doing pre-purchase surveys, not maritime. Which means there's a whole different body of state law applying to you, and the maritime stuff may not. But there are plenty of other claims that you're handling and jobs and assignments you've taken that are not pre-purchase that are covered by maritime law. And then you've got this weird mix. Okay, do I have to know the state law? Do I have to know the maritime law? Well, the answer is you're gonna have to know 50 different state laws where, depending upon where you're working, because you guys can get a call on your cell phone and you're on your plane or in your car or wherever it might be, heading off to a completely different state with completely different rules that you may never have been there before. So the lawyer's chorus caveat here is every jurisdiction's a little different. And what makes this really hard for you guys is a lot of what applies to you is state law, and it's different everywhere. Having said that, when maritime law applies, it comes in and it preempts the state law. So if there's a maritime concept in the law that is spoken, then you can just take the state law and tell the state law court, you can't go with what you know here. There's a whole new body of law. And this will completely flip out state court judges all across the country. I've seen it. I was in New York on Long Island last week, 2 weeks ago. And I walked in and I said, we have a maritime case here. And the guy goes, I don't know anything. What's a maritime case? Well, that means that your law and what you've been doing for the last 30 years on the bench has no bearing whatsoever on what we're going to have to do here today. And that happens all the time, which is kind of scary sitting in your spot, right? Because imagine that all the judges, if I had a room full of judges, of state law judges, they would have equally, actually, they would know less than you guys know about the law in the maritime sphere. That should frighten you, because it's frightening when we as maritime lawyers walk into a court and realize that the judge knows very, very little.
Case maritime or non-maritime?
In the context of what you guys are, one second. The question, what would make a case maritime or non-maritime? So in the context of what you guys are doing, almost everything you're doing on the blue water side is going to qualify unless it's just for the sale of the vessel. So if you're doing some work for either cargo or a situation where the charter it has ended and you're coming in post-charter, there's a high probability that you're going to end up in the maritime sphere. But if you're doing a pre-purchase survey, whether it's for a ship or a yacht, that by its very definition is not maritime. However, that's a big chunk of work for a lot of people, are the pre-purchase surveys. You're doing more blue water, but there are a lot of people that is their bread and butter, even when they're doing other work, because there's a lot of that. and it's easy and it's quick money, and you're not there flying out to a ship or being away from the family. So there's a lot of that, and that's not maritime. That's all state law. So you've got this mix. In the first place that you can find a duty is a fiduciary duty. And I gave you the definition because you're not going to remember it when you leave here. Of all of the garbage in the legalese, it's when one person has a duty to act for or give advice to another on matters falling within the scope of the relationship. So the key here is that you really, really have to lay out the scope of the relationship, which you do in contract. No matter what the scope, let's take an example. Let's say that you had about half the room was doing some sort of casualty damage work. So you've got an adjuster, and you go to these events, and I don't know, you were at Miami or something, and you stayed up for the all-night poker night, and you've been drinking with this person at all of the events. They're sending you 25% of your work, and they're just a great person that you're tight with. They're giving you, again, 25% of everything you make. You just happen to get a one-off for, let's say he's a yacht owner. He hires you directly, the boat sank, and he asks you to take a look. Okay, 2 years goes by. You're still getting 25% from your drinking buddy who shows up on the opposite side of a file. You get a call one day, and you're just showing up for the yard, for example. And the yard is not a target. Boat sank a second time. Not a target. You're just showing up as a prophylactic measure for the yard to be present and have their own surveyor. So now you've got your buddy on the other side of the case for that owner who's making a lot of claims, but you're not hired by your adjuster that normally hires you because you're already on for somebody else. Here's the sticky wicket. At what point do you say, you know, you might want to ask if that boat has sank any time in the past? Anybody think you could ask the opposing adjuster or let your buddy know that the boat might have sank before? You can't do it, right? You absolutely can't do it. But it's real tempting when you're standing together having a beer. But you can't do it. And that's the easy one now. So there's the easy one. Now let's take that same point. What happens if the adjuster did hire you to go out there and you show up and you go, this boat looks kind of familiar. I think I've had this boat before. And that ever happened to anybody? I think I might know something about this one. That's where it starts getting more difficult. Because somebody else hired you 2 years ago. You did a report. You know about this boat. Your buddy who gives you all your work just hired you. You show up and you go, uh-oh, I know about this boat. Anybody? Where's the show of hands? At that point, can you tell your adjuster buddy that this boat sank 2 years ago? So here's where we go. We've got some heads shaking in the back. No, you can't do it. And we've got some other thoughts of folks in the front going, well, maybe you should. And so this split of opinion is where it starts getting interesting.
Step away from it.
The answer might be right there. The answer might be you might have a conflict problem that's developed, and you might have to step away. Now, how you step away is also important so that you don't breach any fiduciary duties. You have to tell your buddy without telling your buddy anything. So that creates its own problem, right? Now, hopefully you're good enough friends that you can just say, I got to recuse on this one. And they don't ask too many questions. But how you do that, you can breach your own duty right there just trying to do the right thing in stepping away. Now it gets even more interesting. what if you're standing there for the yard who doesn't have a target, you're just standing back, and two other adjusters are arguing about the calls and whether or not it looks like this boat has sank before? Say again? Bingo. Bingo. The right answer is there. You have to say nothing. So I don't know how many of you are local enough to know that we are very near an agency whose acronym is Never Say Anything, right around the corner from where we are. I mean, we're, not quite spitball distance away, but Never Say Anything is a good takeaway from this fiduciary duty discussion. Correct. That's perfect. I almost planted this guy. I mean, that's great. That was right into my next point. There are limits to this Never Say Anything. The Never Say Anything is if you're under a subpoena, if you are under oath, that's not a privilege necessarily that you get to assert. You might want to let whoever the attorney is know, hey, you might not want me up there, so that they can figure out what they're going to do. But when the moment arrives, you can't refuse to answer the question. You can do it slowly so your attorney can object. Please. There's nothing worse than the answer when I'm trying to go, oh, shit, it's too late. Can I unring that bell? So that's dead on. Yes, sir.
What you've just been talking about, that boat sinking is a public record? Does that make any difference?
Yeah, for those in the back, his question is, what happens if the boat sank and that's a public record? Now, this is a very, very salient question because of what's been going on in the United States over the last 3 years. Have everybody heard of the Uniform Titling Act? All right, so here's the short version of that. There are several states, Florida being the largest and most populous for recreational vessels, that now when they issue a title on a boat that has a casualty, it's like it's going to get a big scarlet letter A. The Hawthorne book, it's going to get the big stamp. And so that's now making your question very relevant, because most public info, you have to be able to say, I can certify that this is an open source. It's the same as this Never Say Anything agency. If you can certify that you know from a public source and you can cite to the public source, then you can say it. So it's a very interesting question now with the uniform titling, which is what Connecticut now has it. Florida has it, which is the big one. There's like 5 states. It's escaping me right now, which 5. Then you might be able to say this thing has a prior claim on it. And in order to do that, though, you really want to go have seen that in the record, because otherwise you're using non-public information, your inside information. So it's all about open source.
Does that apply to things like, you've got Carfax for automobiles, and there are ones out there for
boat history report, for example.
Exactly, and where they have catalog and they're tracking any maritime boating casualties, accidents, claims. That type of stuff.
Before you say it, if you really, really, really want to say it, but you know you can't, go check boat history report. If it comes back, then you can say only what's there, because that's part of your normal due diligence. Correct. If it's, and we're in the infancy of this whole movement to put the scarlet letter A on state titles. Federal stuff, which is where most of us work, is in the federal realm. Coast Guard documented vessels aren't going to ever have a scarlet letter A on the document. That's just not in the works. That was shut down a long time ago. And knock on wood, hopefully it never comes back to the forefront. The National Association of Boating Law Administrators is what's driving, all the states are together driving this issue on the state titling side. The key element here, as this gentleman pointed out in the very beginning, is it starts by defining the contractual duty. So that's our second one. Where does the duty come from? We're going to look to the contract. Guess who's in control of the contract? You are. You've got the power here until you give it up. So be very careful to lay out the scope very carefully. If you're doing cause and origin on a damage casualty, say it. If you're not, don't venture into areas that you're not supposed to be talking about or getting into. If you're doing on a sailboat or a large yacht, you know, 105, 130 foot sailing yacht, that's some pretty complicated rig stuff. Most people are not going up the rig. They're hiring somebody else to go up the rig. So if you're not going to do it, make sure you indicate what you're going to do and what you're not going to do. How many people are taking on doing compression checks? Yep. See, but here's my point. Somebody is going to say, I thought you did compression checks. And I've got an engine that's crap. So you have to indicate what you're going to do or not do. Right. I mean, 40 pounds ago, I'd go up the rig, but I can't do that anymore. Well, I can, but somebody has to drag my butt up there instead of climbing. But that's my point, is that you have to say or not say what you're going to do at the outset. And failure to do it at the outset is where you get yourself into deep, deep water. So your duty comes from your contract. You're in control of your contract. Use it. Now, there are practical limitations to this. You don't want your contract to look like an insurance policy. If it did, it would be one line that says, I'm going to do a survey of X, except for the next 50 pages of exclusions of stuff I'm not going to do. That's what insurance policies are. You don't want you, I mean, as a practical matter, nobody's going to hire you. So you don't want to necessarily do that. There are limits, practical limits. Now, where else? So we have fiduciary duty generally by state law. We've got the contract duty, and you get to define that. Now, here's where that maritime part comes in. There is something reasonably peculiar to maritime called warranty of workmanlike performance, which is a subset of contract. Anybody heard of warranty of workmanlike performance? Okay. For those of you who didn't raise your hand, you need to know this, okay? This is a big, big deal. In fact, this is where most of the liability for surveyors may end up coming from at some point in time. And there's Ryan versus the stevedores, or there's Ryan stevedoring, etc., versus some ship back in like 1971. And this whole Ryan concept put in place the warranty of workmanlike performance, which is peculiar to maritime law. And that's one of the things that the judge in New York that I just told you about dropped his jaw and like, what the hell is that? Well, that's our primary cause of action. What the hell is that? So you have to know this warranty of workmanlike performance. It is a subset. And I think I gave you, correct me if I'm wrong, everyone, but I think I gave you the definition right in there. So again, you don't have to be negligent. Now, warranty of workmanlike performance kind of parallels negligence, but you don't have to be negligent to find yourself liability under a warranty of workmanlike performance claim. So be very careful to understand that it exists. And I've gone on a little bit and given you some citations that you don't really need to get into now, but for further reading so that you have a better concept when the time comes. Warranty of workmanlike performance has two cases that go with it. The key element there is that you don't have to be negligent. Where else can we have a duty arise? Anybody ever heard of third-party beneficiary contract liability? You need to. You're prime targets for third-party beneficiary contracts. So here's the deal. In your contract, where you're in control, you could find somebody who is not a party to that contract has the capability to sue you for what you wrote in your report. That can be a bit mind-bending, but here's how that works. If in your contract you say, I am doing this report to be submitted to Lloyd's underwriters, you have now identified an individual carrier or syndicate, as the case may be for Lloyd's, who can reasonably rely upon your report. And when you get it wrong, Lloyd's can sue you because they are an identified possible third-party beneficiary. Now, if you just say for a carrier instead of for Lloyd's syndicate, they can't make that claim. I see some looks of like, if WTF had a little bubble, like above the head. Well, what I'm telling you is, if you're going to put your scope in, you're going to say who it's for, and you know it's an insurance survey to get cover, don't say Lloyd syndicate number, blah, 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 subscribed to by the following 6, rich barons that are putting their houses up to be involved. I mean, that's how ridiculously you could theoretically go. Right. But if it's what you identify in your contract with that vessel owner. A carrier, any carrier, doesn't matter who, as long as you don't identify them. Because once they're identified and then that carrier reasonably relies upon your report, they have the possibility of bringing this third-party beneficiary contract claim. Very, very different if you're hired by the carrier. That's totally different. That's completely different. But this concept, I just took the most simple one, but you can see how you can apply this in various ways by naming different people. Naming, for the contract with X person to purchase the vessel. Well, now you've just drug in somebody else that can sue you in if they get that thing and can rely on it. You put the one guy who's paying you, not the other party. Because that one guy who's paying you, if they give it to the other party and the other party relies on it and their name is specifically in there, then they might have a claim against you. You guys did this? Okay, so this is why we have a lot of but there's more on the ethics to come, actually.
So what about just simply naming the individuals that were present at the inspection?
Naming them present, you're doing something factual. You're not saying this report is for. That's the part that gets you in trouble. So we've gone through quite a few things here, but we haven't gotten to the one that is the big one, which is negligence. Negligence, of course, is duty, breach, causation, damages. Right now we're in the concept of where does my duty come from? The law implies that you will act and behave as a reasonable person. Is there anybody else in the room who's been through first year of law school? Okay, by definition, I can no longer be a reasonable person. Anybody who's been through Torts 101 is worried about sitting down with this kid named little Charlie McAfoos who takes the tear out from underneath you. And it's like a famous case. So you're just not a reasonable person anymore because you're always looking for little kids taking chairs away from you. But a reasonable person is your standard. How touchy-feely is that? It's very touchy-feely, which is why there's a ton of fighting about who's a reasonable person, what's the proper standards of care, etc., and how that works. So that's your other source for duty. So for those of you who just walked in, the roadmap and where we are, we're talking about sources of your duty. The whole concept here is surveyor duty and to whom. We've gotten through all the sources. Now we're moving on to what are, recapping still. The sources that we just covered: a fiduciary duty under state laws varying by jurisdiction, contractual privity as a basis for duty. Subset of that is a warranty of workmanlike performance. We covered third-party beneficiary contract as a source of duty. And we just hit the highlights on negligence as a source of duty, reasonable person, duty of reasonable care. Now, I also said in the roadmap, the next place we're going is the other duties that are not yours, but you can't possibly be doing your job without knowing them. The loaded word, unseaworthiness. You see why it's the loaded word, right? But you still have to understand the concept. And here's the really hard part. Unseaworthiness can have completely different definitions. As you guys, it sounds like you've already done some of this. The big picture definition, of course, is reasonably fit for the intended voyage. The famous case is Gun Sapporo, who was a little crazy and he ended up killing one of his crew members in 1950 something. And the vessel was not reasonably fit for its intended voyage because it had a failure of manning by virtue of having a crazy person who killed someone with a knife. Unseaworthiness, though, is important also in the context of the insurance side. And you guys are doing some of the casualty work in the insurance side, et cetera. If you say that the vessel is unseaworthy, there's not going to be any coverage, depending upon when you said it became unseaworthy, which is part of the reason you don't say whether the thing is seaworthy or not. It is completely a loaded word. So here's the concept, though. The vessel has to be seaworthy at the time the policy attaches to the vessel, or there's no coverage, period. The vessel has to be seaworthy at the time it breaks ground from the dock, or the carrier could avoid coverage. The master and crew's knowledge of the unseaworthy condition may or may not be imputed to the owner. So you can see this is part of the reason we don't say seaworthy, because it's such a nebulous Gordian knot. Further, there's a second concept. So it sounds like you guys have covered this seaworthiness, so I'm going to kind of skip over. You covered it on another speaker, it sounds like. The next beat it to death, right? Well, at the risk of the fact that I am actually a little long in the tooth, I'm going to go to the umber me fide. Anybody ever heard this Latin? Umber me fide? Okay, when a lawyer says Latin, that means bullshit to follow. Again, I'm blunt. I apologize for cursing, but it just gets the point across. Umber me fide is this Latin for the utmost good faith and fair dealing. It comes from the insured. And so when the concept was that all these guys would sit over in the UK insuring vessels around the world, but they weren't going over to Australia, they were just signing and saying, sure, because you've told me that the boat's in great shape or the ship's in great shape, et cetera, et cetera. Because of the way historically this is developed, this has put this duty of umber me fide into the hands of the owner who is getting the cover. Now the problem that develops, this is my little reminder of how much further I can go. Keep me on track. Sorry. So this umber me fide concept, you could actually end up being the agent of the owner. And you don't want to completely blow it when you are not truthful or look to the other direction on something. Because it may well be you help that owner get some cover, but when the casualty arrives, there's nothing. Because you didn't say something that should have been said, and you ended up being the agent of the owner. Who's going to be really mad at you when their $1 million is gone? The owner that hired you. Then we're going to go look to the contract as well. And they're going to say something like, you were my agent, I was relying upon you, and you decided because you had drinks with the broker last night not to do X, Y, or Z or say something in the report. Now, I'm using the recreational, but this same concept applies on the blue water side too. Just happens to be a recreational example.
I have a question.
Sure.
Should the agreement have
Absolutely. Absolutely. And I've given 3 or 4 times, I've given talks to surveyors, and there's like a whole hour and a half on agreements. It's like a whole, so we don't want to go down the path too much, but that is one of the clauses you might like to have, is some venue provision, and you want to make it favorable to you in the choice of law. The next thing you guys have in your handout is largely for you to have sources to go to after today. And you'll notice that the first one I bring up is our sponsoring organization here's important excerpt that helps you work through the decisions of, one, whether you should even take a file, and when you're in there taking the file, how to solve these sticky wickets we've been talking about. Being a fair and blunt person, I have also included NAMs and SAMs. Now, with all due respect to my brethren and those other organizations, etc., just look at the page, everybody. We've got Alpha and Bravo are this organization's excerpts on the small vessel part and the general part. Compare and contrast in number of inches what NAMS has to say. I've got to tell you that I was very pleased to see a more in-depth set of statements. And I've reproduced them for you. I'm not going to read them all. You guys have read them. Those of you who are parts of the, or most of you, if not all, are members of the organization here anyway, so you know them. But compare and contrast. These are the sources. If you ever get into this, what the hell do I do? Take a minute, pull out your 4 pages here, and read the salient ones that matter to this topic. Now, the problem, of course, is that you're going to get into conflict issues that aren't really covered by any of the organizations at a level and detail that you can really get to the answer to your question for conflict. But conflict is important because sometimes the absolute best decision you can make as far as a client goes and which assignment to take is to turn it down. The smartest decision sometimes is simply turning it down. So one of the things that I've also included for you to help you work through your individual issues after today is I have included the salient points from the attorney rules on conflict. Now, it's not the whole damn thing, but it's a lot because, you know, lawyers can write 5 times more than you really need to write on any particular topic. But I've given you the salient ones. I just happen to use Maryland because we're sitting in that jurisdiction right now. Confidentiality of information is specified. And then you'll see the conflict rules, really pretty clear. So if you have any issue, don't reinvent the wheel. There's no point. There have been countless hundreds of hours spent. And if you guys, I'll have a PDF of this with the hot link to those. If you really, really want to know, there's about 5 to 6 pages of comments that follow each of these rules. So if you really get into something, if you don't know the answer, you can go to any jurisdiction and get this. But this is really the way for you to work through your problem quickly and not spend 5 hours trying to figure it out. Just use the principles. I've even put some highlights in for you guys because this is one that is not covered in any of the organization's rules, which is what about the duties to the former clients? And it gets even more complicated when you're not out there solo, when you're working in a group of surveyors. Because that group of surveyors, when you read law firm, think the surveyor group. And when you read attorney, just insert the word surveyor. It's all extremely applicable to help you work through your problems. And the best ones are the ones you don't take. And particularly think twice if a lawyer is hiring you. And the lawyer owns the boat, really think twice. And don't think twice about tacking on the, PITA adjustment. Yeah, the pain in the ass factor. Okay, that's really what it comes down to. And I'm serious, because I've defended surveyors who have been hired by lawyers, and it's horrific. What's that? Yeah, absolutely, absolutely. That is the reaction. Again, and the really big problem with that is there are like 10 admiralty lawyers in the state of Maryland. There are thousands of lawyers here, and every last one of them thinks they know what the hell they're doing in this sphere, and there are like 10 of us who actually do this stuff. So that's why lawyers in general are such a pain in the ass to deal with. And again, I'm blunt, so I apologize. So take this stuff, don't peruse, deep into it, but I give you all of this so that when you walk out of here, you will actually be in a position to solve your own problems. Just stick it in a file somewhere, not the circular file because it doesn't do you any good in there, but stick it somewhere so you can pull it out when you need it. Now, the next thing I promised in our roadmap is to go over a little bit of what the claims are that would be brought against you, have been brought against other surveyors, so that you can do the appropriate CYA like we've been talking about in the contracts. And I put them to you now in the order that they are most likely to occur and potentially most successfully to occur. The first, breach of contract. Pretty straightforward. Everybody knows breach of contract. Somebody doesn't do what they're supposed to do under the explicit terms. By the way, have a contract. I know that sounds like I'm missing the whole train, but you would be shocked how many people do not have a contract in this surveyor world. And they will say, we had 1 or 2 email exchanges, and then I sent him my report, and in my report it says that I have a limitation of liability and everything else at the very end. He didn't sign anything. The indemnification and limitation provisions, courts are not really inclined to enforce those unless there's a signature from the person against whom you're enforcing it. Get a contract. Today, DocuSign. From my phone, I can have you sign something, and you can sign something from your phone. Click, click, click. Literally 3 clicks. You're done. It's not hard. I've been shocked how many people don't. But breach of contract, that's our first one. Negligent misrepresentation. So this is a subset of negligence. It is a standalone, and it is what most surveyors and the classification societies have lost on. It's not just a straight negligence that they lose on, it's negligent misrepresentation. What does that mean? Knew or should have known and failed to say. Now, if you knew specifically, that's more like fraud. So it's when you can't quite get to the point of knowing what's in the surveyor's mind, but they probably should have caught something. That's where you'll find this negligent misrepresentation, which is a subset of negligence, a specific kind with its own set of case law that goes with it. The cases where the surveyors and the classification societies have lost, this is one of the big areas. The next thing is, of course, your garden variety negligence, which is sort of like professional negligence. But you don't find people winning as much on that as that you do on the negligent misrepresentation. And then the breach of warranty of workmanlike performance we discussed. But remember the caveat. It has to be a maritime, and a pre-purchase survey is not maritime by definition. Buying and selling a boat, not maritime by definition. Once the sale occurs, once the vessel's in navigation, once you're dealing with the cargo, once you're doing the casualty, all that stuff's a different animal. And then finally, the breach of fiduciary duty, which is where we started. And I put that at the end because not every state even has it as a standalone cause of action, as we discussed. So now we're at the spot of having gone through the vast majority of our roadmap. I've left myself 9 minutes approximately if we want to have discussion. However, we can hit highlights on the last 2 pages, which are the actual cases that matter. There are not that many of them. So before we get into that, we've got about 9-8 minutes. Are there some burning topics that you guys want to talk about? Sir. Well, that's more of a breach of contract when you were, but it's the failure to use your own utmost good faith and protect that person's interest. It would include letting your buddy you've been drinking with and playing cards all night know that boat sank 2 years ago. It would be doing things like taking remuneration on the side for something. I mean, that's a more incredibly bad, unethical example than the more nuanced ones we were discussing earlier. Any other burning questions?
As far as not getting a signature on the contract, what about email concurrence?
Email concurrence is a bare minimum because there are some states, particularly for those of you who have attorney's fees provisions in your contract, that really will not enforce the attorney's fees without a signature. There are some states that require signature for certain indemnification bits before they'll really feel like enforcing them. So the assent is there, but as a practical answer, theoretically that should work. As a practical answer, a lot of the courts are disinclined when you get into the trees at individual items, particularly attorney's fees, which a lot of you have, to actually give it to you unless there's some signature assent, electronic or ink, for those that still do ink. Any other, Randy?
When we are now inspecting a 2018 Beneficiary, it has a placard, unlike the WYC placard, which is probably something that I'm sure I'm going to understand. And the placard says it was built to European MCA standard, and it carries an A rating, therefore it's good 6 meters away, like these folks right here on the safety are going to start coming in.
Right.
Are we not saying that this Beneficiary order has been built?
No. What I would say is this boat purports to be compliant with CE or ABYC standard. The boat and the placard purports to be. You then at least know what standard is. And by the way, has anybody done a Beneteau 40.7 recently? Okay. Anybody read the Cheeky Rafiki report?
The what?
Cheeky Rafiki, 5 guys died. You guys remember that? So, yeah, Keel. But here's the interesting thing. In my world, you get to see the dirty, dark secrets from a lot of different manufacturers. And that one just happens to be out there. They designed for an extra keel bolt that they never put in on any Beneteau 40.7. So the design of the keel and the boat was not as built in the entire production line. And the reason is because they had no structure to put the last keel bolt into. They had no stringer where it was supposed to be. So I used to do offshore stuff on 40.7s. Now I do in the bay. But there are a lot of boats out there. You guys know some of them that I don't. But in my position, you see a lot of manufacturers with these dirty little secrets. I mean, I've seen boats where the scrimp is put in backwards when the boat's laid up. And so there's like a whole side of the boat that's delaminating. And I've seen those same boats sold 2 or 3 times. Here's an open secret, which I love. Everybody knows gunboat, right? The big gunboats, the sail catamarans, another Peter Johnstone deal. So about a week before a gunboat was sold in Annapolis at the boat show for like 1.5 or 8 million or something ridiculous, Johnstone filed bankruptcy. And in his bankruptcy pleadings, it actually says, oh, this is going to be on the web. Peter's going to hear this. But in the bankruptcy pleadings, it actually, gunboat says, all the resin is bad and all of our hulls are going to delam and fail. every last boat we've built are all going to fail and all going to delaminate. They actually say that in the pleadings. It blows my mind. And then some poor guy, week and a half later, drops 1 point whatever million for a gunboat that the manufacturer has just said is going to delaminate and is worthless. Just saying, there are lots of little dirty secrets out there. And those are just two that happen to be in the public domain and open secrets. You guys have seen them too, but you haven't necessarily put them in the open domain, so you're not chiming in now. But be careful to use your resources as well, because there are some things that are so well known. This boat X is a POS for reasons 1, 2, and 3. And it's universally known, and if you turn a blind eye to what is common knowledge, for whatever reason, you can pretty easily find yourself, why didn't you do this modicum of due diligence? Why didn't you type in Beneteau 40.7 keel failure? And up pops the cheeky Rafiki report. I mean, how many people in this room knew that before we just had this discussion? 2? I mean, at the very least, guys, go Google whatever you're going to go get on and survey before you show up to it. Because there's a tremendous amount of Yep, exactly. All those safety briefings. All right, so my little ringer went again, and I will just refer you in your leisurely reading. Since it's kind of heavy in case sites, I do suggest getting a bourbon and sitting down. But these are the big cases I've given you the last 2 pages, and I've given you just the parts that matter. When you see classification society, read in surveyor, because it works the same. But most of the cases are from classification societies. All right, the hook has come. Oh, and if there's anything I can ever do for you, I like capitalism. Happy to help you out. I'm working all over the East Coast, the Gulf,